Hi, this is Tom DeVoto, and this weekend, and the weekend of August the 13th and the 14th, there was a tragedy that took place at the Indiana State Fair, and some of my clients, friends, and even family members have asked me a little bit about what I thought about that. First of all, I am not licensed to practice law in Indiana, but I have done a brief research of that issue, and like many states, Indiana has what is known as a waiver of sovereign immunity. And that means there are caps on how much money the victims can get from the state, assuming that the state is liable for what happened. My research shows that at the present time, the waiver of liability for accidents like this is a cap of $700,000 per person, but there's a $5 million cap in the aggregate, which means that no matter how many people get hurt or killed by reason of an act of negligence on the part of the state of Indiana, the maximum amount that will ever be paid is $5 million. So take, for example, on a really gross, simple basis, if there were 1,000 people that were injured, you would divide 1,000 into 5 million, or 5,000 a piece would be the most money that anyone could get under that circumstance. Now, the reason I bring this up is twofold. First of all, caps by the state in some cases make some sense because the taxpayers would have to pick up the tab if there were no caps, assuming arguendo the state doesn't get insurance. In Missouri, we have caps that are actually in the range of $300,000 per person, but they can be waived if the state or the state entity purchases insurance up to the limits of the insurance company's limits or on the policy. So our law, as near as I can see, is a little bit different than Indiana. Other issues that will come up in the Indiana case include whether or not the stage was owned by an entity that leased it to the Indiana State Fair. Could lead to claims that it was set up negligently. There could be claims against the manufacturer of the stage itself or components of the stage that failed, and all of that will be the subject matter of investigations by engineers and metallurgists to see why the uprights collapsed, and obviously they bent and they collapsed in the wind. Any liability on the part of the state of Indiana would come from their failure to warn. Apparently there is some indication that they had known for hours that a storm with the potential for high winds was approaching the state fairgrounds. We'll all have to wait and see how this plays out. But since my friends and clients have asked me to comment on this, I thought I would comment on it and put it on my website. Please be free to go to my website if you want any additional information concerning product liability. I have an entire section of my webpage dedicated to that topic. Thank you.